In this video, I'll be covering the issues related to EIAs in England and offer solutions of how they could be improved to offer better environmental protection. I'm going to quickly cover what is an EIA. An environmental impact assessment is a formal procedure through which decision makers gather environmental information about projects, identifying the potential significant environmental effects and risks, and take this information into account in decision making. This is in the hopes that an EIA can offer both environmental and economic benefits, such as reduced time and expenditure of project implementation and design, avoiding treatment and cleanup costs, as well as reducing repercussions of law and regulations. So the legislation that covers EIAs. EIAs in the UK are covered by the Town and Country Planning Environmental Impact Assessment Regulation of 2017. These regulations apply to development which is given planning permission under Part 3 of the Town and Country Planning Act 1990. The 2017 regulation are the UK's way of implementing EIAs into legislation to comply with EU regulations, Directive 2014-52 of the European Parliament. So I'm going to quickly cover some of the issues with EIAs. Public participation. Public participation is a mandatory part of the EIA process as of Article 31C of the Town and Country Planning Environmental Impact Assessment Regulation 2017. This is in the hope that it will inform decision making, minimise conflicts, increase accountability and transparency, as well as build trust between developers and the public. However, there are significant issues with public participation involving EIAs in England. Timeframes. Consultation bodies have 30 days from when the notice is published laying out the plans of a development to make an appeal, as of Article 19(6) of the Town and Country Planning Environmental Impact Assessment Regulations 2017. This regulation favours the developers as the 30-day period can be considered too short for the public to be able to gather sufficient evidence to appeal against the development, making it much easier for the developers to bypass the concerns of the public. So, public involvement. Public involvement is a broad term that can be divided into different tiers, including informing, consulting, participating, or negotiating. Article 30(1)(c) of the Town and Country Planning Environmental Impact Assessment Regulations 2017 states developers should inform the public of a decision relating to development plans. This is the weakest form of public involvement as it is effectively a one-way flow of information from the developer to the public. And while the public have the opportunity to appeal development plans, this is weakened by the aforementioned 30-day timeframe. The diagram on the right shows Sherry Arnstein's ladder of citizen participation. The current regulations of the Town and Country Planning regulations fall within the tokenism realm of the ladder, which can be considered an issue of EIAs currently, as public participation could be stronger if there was more consultation and partnership. So, judicial review. Environmental judicial review is a public law designation in the field of environmental law that scrutinises the lawfulness of decisions by the government, local authorities, environmental regulators, and other public bodies. Courts of law will not accept a petition for judicial review if a party is not sought administrative relief first, but administrative appeals can be frustrating if there is corruption or delay due to improper outside influence or a backlog of cases. Judicial review may be complicated by certain legal and practical limitations, such as high costs of obtaining legal representation and expert witnesses, the possibility of costs being awarded against an unsuccessful petitioner, and standing requirements that severely restrict the scope of possible plaintiffs as litigation is very expensive. The cost of judicial reviews are capped at £5,000 for individuals and £10,000 if it is a collective or NGO bringing a case. This is supposed to make it easier for a judicial review to be accessed by the general public, but these high costs will likely put many people off from submitting a case against an EIA and makes it easier for developers to harm the environment without any repercussions. Finally, judges are often reluctant to overturn or even scrutinise administrative decisions, particularly when a dispute centres on technical issues that are within an agency or ministry's realm of expertise, meaning often those who take government bodies or developers to court lose the case. So issues with EIA consultancies. Moving away from the criticism of public participation, there are issues related to environmental impact assessment consultancies. Firstly, EIA qualifications should be attained by consultants and specialists who work in the field for a better understanding of how a project will work and how it will impact the environment. However, whilst it is strongly recommended competent experts work on environmental statements to ensure completeness and quality, there is no law which states that consultants need any form of qualification to complete an environmental statement. In addition to this, environmental consultants who work on EIAs are private companies, and therefore there is competition between these companies. Developers are free to shop around when looking for consultants to produce an EIA. So if an EIA is considered too strict, the developer may look elsewhere. EIA consultancy try to make sure a project won't cause harm to the environment, but don't want to upset their clients, but environmental protection may not always be at the forefront of EIAs. I will briefly discuss the case study of HS2 and how it highlights the weaknesses of EIAs. High Speed 2 is a high-speed railway line that is under construction in the United Kingdom with new tracks stretching from London to Birmingham. There have been several concerns about the environmental impacts of the HS2 development and therefore it has been heavily contested. HSTU Objectives issued a series of legal proceedings hoping to block the development at various different phases of its development. The final EIA was deposited in Parliament as part of a hybrid bill in 2017, and there was an 8-week consultation period on the EIA, allowing members of the public to comment on their disagreement. Despite the clear disapproval of the project and its consequences to the environment, including damage to 5 internationally protected wildlife sites, 693 local wildlife sites, 108 ancient woodlands, and 33 legally protected sites of special scientific interest, these concerns were never taken seriously and the project commenced as originally proposed. This highlights the weaknesses of EIAs, as despite public participation allegedly being an important aspect, this case study shows that often public involvement is not considered when the opinions of the public does not align with the interests of government or developers. So I'm going to quickly cover how EIAs could be improved. A possible solution to improve the way environmental impact assessments are produced is to ensure environmental statements are prepared by the authority rather than the developer, which could promote more consistent environmental standards across all developments. In addition to this, it could be desirable to create an independent monitoring body with the wide powers along the lines pioneered by the former council and tribunals. This could monitor and advise upon procedural standards. It could also commission research and possibly investigate complaints from the public. By removing private consultancies and implementing an independent monitoring body, developers not only have to abide by a stricter set of regulations initially, they have to maintain these standards or risk being investigated by the independent monitoring body with a potential to be fined. So increase public involvement. To increase public involvement, instead of the public being informed after the EIA is completed, it could be more beneficial for the public to have a more active role in the EIA process and negotiate with developers regarding environmental concerns. This would include being involved in the proposal identification, screening, scoping, mitigation, and impact management and the EIA report. More transparency in the EIA process with the public should theoretically mean there will be less public complaints relating to development plans, and in the long term could save developers money by avoiding being taken to court, and this approach would simultaneously promote stronger environmental protection. To judicial review. In the case of judicial review, by implementing the aforementioned independent monitoring body, the public could avoid the need for administrative and judicial review, as the complaints could be investigated by this body. This would encourage members of the public to take action and hopefully get justice, as they don't need to worry about large court fees and the prolonged process of going through both these types of reviews. In turn, the increased likelihood of being found liable for damages by the independent monitoring body should make developers more environmentally conscious to avoid being taken to court. In conclusion, environmental impact assessments are currently in the best state they have ever been in, as the most recent Town and Country Planning Environmental Impact Assessment Regulation 2017 did make improvements in favour of environmental protection. This includes a new penalty system, a more detailed screening procedure, as well as pre- and post built-in monitoring and development. However, EIAs can still be improved on, and a reform would make EIAs more inclusive of the general public, and centralising the EIA process would encourage environmental protection to be designated to a higher standard which is consistent across all EIAs. Thank you for taking the time to listen to this short presentation on the issues with EIAs in England and my interpretation of how they could be improved to offer better environmental protection.